We're talking about Alec Murdaugh today. It's Thursday, it's May 14th. We are going to be talking about what the South Carolina Supreme Court ruled and why. It is a very good opportunity for us to take a look at an appeals court where they overturned a trial, overturned a conviction, and why. And we have some words from the South Carolina Attorney General, Alan Wilson, because he had some thoughts. And of course, if there's a camera, there's a poot. So we're going to talk about poot as well. This is from yesterday because, of course, everything decided to happen on May 13th. State versus Richard Alexander Murdaugh. For those of you new to this case, yes, his first name is Dick. For 6 weeks, I love the drama. Come on, South Carolina. For 6 weeks in early 2023, the eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife, Maggie, and son, Paul. It's written like the intro to a docuseries. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Clerk of Court Rebecca Hill placed her fingers on the scales of justice. The fact that they didn't say greedy, grubby little fingers is restrained. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury towards a biased verdict. Although we are aware of the time, money, and effort extended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. Like forthfucking by the way. Everybody's like, are we sentencing him? The next day. And Judge Newman basically was like, I hope they haunt your dreams. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance and allow him to file a motion for new trial. Nerds, listen up. The procedural history of this is fascinating to me. There were multi-levels of appeals going on here, and that's what they're going to talk about next, because there was the direct appeal to the Court of Appeals and also the motion for new trial going on simultaneously. And then everything ended up back up at the Supreme Court. You can't just go to the Supreme Court. You've got to go to the Court of Appeals. So this is what they're talking about. They're talking about their procedural history here, about the appeal being held in abeyance so he could file the motion for new trial. That motion for new trial had previously been denied, but he filed a motion to allow him to file a motion for new trial based on new evidence, the new evidence being the Courthouse Becky stuff. There's a lot of procedural history here and a lot of work that went on from the defense team. Murdaugh asked to hold that in abeyance, just pause it, so he could file a motion for new trial. The Court of Appeals granted the motion. That was the abeyance. Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising the jury, not to believe Murdaugh's testimony and other defense evidence, and 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror she believed to be in favor of the defense. the egg lady juror. So those are the three grounds that they brought to the motion for new trial that we watched before Justice Toll. The post-trial court, that's Justice Toll, the post-trial court conducted a hearing on this motion on January 26th and 29th, 2024. We were there, by stream. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement of their verdict at the time. 2, whether their verdict was based entirely on testimony, evidence, and law presented in the case. 3, whether they heard Hill make any comment about the case before the verdict. And 4, whether their verdict was influenced in any way by communications by Hill. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill, Courthouse Becky, say before Murdaugh's testimony, quote, looks like the defendant is going to testify. This is an important day, or this is an epic day. And that it was rare for a defendant to testify. Juror X said that those statements did not impact the verdict. Those statements are improper. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for the new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said, quote, to watch his actions, to watch him closely. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, quote, to me, it felt like she made it seem that he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror C's affidavit gave more detailed recitation of Hill's comments. Here is what that affidavit says. Toward the end of the trial after President's Day break, but before Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled by the evidence presented by Mr. Murdaugh's attorney. That goes against the presumption of innocence. And the juror said, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to, quote, watch him closely immediately before he testified, including to, quote, look at his actions and to, quote, look at his movements, which I understood to mean he was guilty. Juror Z testified that when the jury began deliberations, Hill told the jury, quote, this shouldn't take us long. She treated herself as, or styled herself as, the 13th juror in this case. And that is why there's a new trial. They go on to say that although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court, which means they can consider it. Juror P testified that the day Murdaugh was to take the stand, Hill made a comment to, quote, watch his body language. He denied Hill's comments influenced him in any way, footnote 1. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Multiple jurors heard Hill say the same thing. Footnote 1. Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned into the proceeding on court TV. I remember that. The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. Following the jurors' testimony, the state called Courthouse Becky as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day that Murdaugh testified and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors a little talk, instructing them to pay attention, and that the day was a big day. She denied attempting to influence the jury. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, footnote 2. Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her. She acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. So the motive then? Oh, there's a footnote. Footnote 2. As her book title suggests, it turned out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. Hill denied allowing the press to view the exhibits. I changed the word. Including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Deadass lied to Justice Toll's face, no cap. Although the post-trial court limited discussions of Juror 785, we'll get to the footnote in a moment, whom the trial court dismissed the day deliberations began for allegedly discussing the case. Oh, that's interesting. We're at Egg Lady, juror. They say the discussion about Juror 785's dismissal for allegedly discussing the case with third parties. It allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from Juror 785's ex-husband. Hill claimed that the juror was very talkative. She's telling them everything. While Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. You should never know this about a juror. You should never, ever, ever have this type of conversation with a juror. In response to the post-trials court questioning, Hill continued to deny initiating or engaging the juror in discussions of those matters. I don't believe Hill on this one. In the affidavit, the Egg Lady juror related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers question the ex-husband about the posts. In the light, for me, in the light most favorable to this juror, if you have an ex that you have a restraining order against, and all of a sudden you are being told that law enforcement is now contacting that ex, I can see very reasonably that could cause someone to panic. Because what is the fallout going to be if they have now contacted the ex? So Becky is alleged to have told the Egg Lady juror that law enforcement chatted with the ex about posts on Facebook and then offered to reinstate restraining orders that Juror 785 had against him and speculated that, quote, the Murdaughs probably got to him, to the ex-husband, when he called Juror 785 the morning of the verdict. Juror 785 asserted that Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. When I have evaluated this, there are parts of this that I believe more than others. I believe that some of this may be exaggerated a bit. Not all of this rang true to me, but I don't think all of it is exaggerated. I think some of it may be, but I think that she and this juror had an inappropriate conversation. I think that was initiated by Courthouse Becky. I don't know if some of it was then bolstered after her conversation with defense counsel, but I think that the conversations happened. Egg Lady juror also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's attorneys presented. I believe that part. Absolutely. Numerous jurors reiterated that. The court now goes on to Rhonda McElveen, the Barnwell County Clerk of Court, who assisted Hill with the trial. Rhonda testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. I believe Rhonda McElveen 1000%. After Hill had given a juror a ride home, McElveen counseled Becky that it was inappropriate. And while Hill admitted that she gave the juror a ride, she claimed that the bailiff was with them and they did not discuss the case. Footnote 5. I had forgotten about that. Footnote 5. At the hearing, Hill denied giving a juror a ride home. Hill lied in that hearing multiple times. I don't believe Hill for a minute. Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, to staff, and to media members strikingly similar to those Jersey reported. I believe Rhonda McElveen. McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. Was that part of the plagiarized part or nah? In its order, the post-trial court, Justice Toll, declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. This is the thing I've been talking about this whole case. The standard in South Carolina and the standard that the federal Supreme Court has are different. The federal Supreme Court and many other courts do not place the burden on the defendant to show prejudice. Most jurisdictions presume that there's prejudice, and then the prosecution has to rebut the prejudice. And I said at the beginning of all of this, if South Carolina shifted their standard to align with the federal standard, then it's a new trial. South Carolina has not had the opportunity to evaluate this since the federal standard changed. And I think it's fair. This is the standard not when we are dealing with external influence on the jury, but when we are dealing with external influence that is particularly a party connected to the state, a bailiff, an elected official, court staff. They carry more weight because they are part of the justice system. Their interference is higher levels of fuckery. The post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. I think Justice Toll was right about that standard at the time. It then found Hill made improper comments to the jurors on the day that Murdaugh testified, e.g., this is an important day or this is an epic day, and that they should watch Murdaugh's body language. The post-trial court determined that Hill's denial of making these statements was not credible, finding that Hill wanted to write a book, which she believed a guilty verdict would help to sell, and that she was, quote, attracted by the siren call of celebrity. Justice Toll also said that Becky Hill allowed her desire for public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Facts. Next, the post-trial court found that these comments did not affect any juror's verdict. It explained that Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing that Juror Z had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors, and that was the more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh failed to meet his burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed the Court of Appeals. This court certified the appeal of the denial of the motion for new trial and subsequently consolidated it with the direct appeal. So then procedurally, it all just got pulled up to the Supreme Court. Whoop. Law and analysis, the Reamer presumption of prejudice. Murdaugh argues he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. He asserts that following Reamer versus U.S. from 1954, prejudice should be presumed from Hill's comments to the jury, and that the presumption is irrebuttable. In the alternative, he contends that the state failed to rebut the presumption of prejudice. The state argues that the jury convicted Murdaugh because he was obviously guilty, because he was obviously guilty, and not because 3 jurors heard Hill's, quote, foolish and fleeting comments about his upcoming testimony. The state contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. We agree with Murdaugh. South Carolina is changing their standard. We agree with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. I think that is the just result. I think that Justice Toll, as a restrained and mindful jurist, also knew it was not her job to change this standard. And I think Justice Toll pretty much teed up a slow pitch to the Supreme Court to take up this question. And the reason, in my opinion, that the Supreme Court directly took this up out of the hands of the Court of Appeal is because this is really the first opportunity South Carolina has had to change their case law. So when we want to talk about how do laws change, this is how laws change. The Supreme Court can't just say, they're not legislatures. The Supreme Court can't just say, hey, our standard's outdated, we should change that. There has to be a case in controversy. There has to be something happening that allows them the vehicle to then evaluate whether or not they are changing their standard. So going forward from this precedent, the Supreme Court has now changed the case law in South Carolina to change the standard that's applied. Because now, if this scenario ever comes up again, this is the binding precedent on South Carolina. And the next set of lawyers will pull State versus Murdaugh, citing to Reamer and say, in South Carolina, we follow the federal Reamer standard per State versus Murdaugh. This case is now binding precedent. Courthouse Becky has kind of welcomed in new case law. Do you know what that also means? That this has not come up in South Carolina since 1954, because this doesn't come up very often. Because everyone knows this is fuckery and this is what you don't do. You don't do this. This is not okay. This is where this goes forward. We clarify today that when faced with a third party's improper contact with a juror, our courts should follow the Fourth Circuit's 3-step analysis as set forth in Cheek. That is the new standard. That is a clarification of this is a new standard. And then they lay out the 3-step analysis from their Cheek case. 1, require the defendant to meet the initial burden by presenting evidence that contacts were, quote, more than innocuous interventions. 2, if this minimal standard is satisfied, recognize that the Reamer presumption is triggered automatically. 3, shift the burden to the prevailing party, the state, to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. Once Reamer is triggered, it is incredibly difficult. This is me interjecting. It is incredibly difficult for the state to prove that there is no reasonable possibility that a jury's verdict was influenced. That becomes difficult. They go on to say that under the framework, we turn to the facts at hand. So they gave us the facts, because the writing is glorious. The facts, the lay of the land with the case law, kind of the road so far of the case law. They acknowledged that they have not always been crispy clear in their case law, and they clean it up. And now we are applying those facts to this law in practice. Now, what are the things? First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified that she made, e.g., "This is an important day. This is an epic day. Watch his body language." The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. It goes on to say that the post-trial court, this is Justice Toll, gave no indication it found the other comments not credible, nor would the record support such a finding. The Supreme Court goes on to say that Hill's attempt to insert herself into the jury's deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write. Her meddling in events around Juror 785's dismissal and her self-aggrandizing conduct throughout and after the trial, from granting favors to members of the media, such as allowing them to view sealed exhibits and sitting a writer with court staff in the courtroom, to granting interviews. As the post-trial court found, Hill was attracted by the siren call of celebrity and allowed her desire for public attention of the moment to overcome her duty to her oath and her office. We have no reason to find that Hill did not make all of the statements the jurors reported. Therefore, we hold that Murdaugh established Hill made comments that the day Murdaugh testified was going to be epic or important, and urged jurors not to be fooled, confused, thrown off, or convinced by Murdaugh, and to watch Murdaugh's body language closely. The Supreme Court finds that Courthouse Becky told the jurors to disregard the defense. The Supreme Court goes on to say, next, we must decide whether these comments were, quote, more than innocuous interventions. The Supreme Court here says, Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility. In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in the case. Even Hill's seemingly innocuous comments that the day Murdaugh testified was an epic or important day became nefarious when considered with her other comments. Oh, I'm sorry. We're in South Carolina. Can we go to Massachusetts for a second? Nefarious. Insinuating that there was something unusual or suspicious about his decision to testify. Therefore, we hold that Murdaugh met the minimal standard showing that the extrajudicial communications or contacts were more than innocuous interventions. This goes to the heart of the case. And the post-trial court erred as a matter of law in refusing to impose the Reamer presumption. They have to determine whether the state met their burden of proving that there was no reasonable possibility that the verdict was affected by Hill's comments. The state contends that Murdaugh cannot complain about the post-trial court questioning Juror Z regarding her affidavit because Murdaugh submitted the affidavit to its post-trial court with his motion for new trial. They say that the right was not Murdaugh's to waive. Thus, the portion of Juror Z's affidavit in which she disclosed her mental process in reaching her verdict was inadmissible. The post-trial court erred in questioning her about that portion of the affidavit. So, where are we now? Well, when Juror Z was questioned about whether Becky Hill's statement or the other jurors was more persuasive, the court is saying, back that thing up, that's questioning the deliberative process. You cannot ask a juror about the deliberative process, and asking the juror if Hill's comments or the other jurors' conversations was more impactful on them violates the province of deliberations, and therefore that part is yeeted. So the juror saying in court that they were more influenced by other jurors is stripped out of this. What stands then is the juror saying that Becky Hill influenced their verdict. The court goes on to say that the post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. So that part has been removed. We also hold that the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence. We reiterate the burden is on the state to rebut the presumption of prejudice. So they're saying to the trial court, you did not apply the right standard. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of proving a lack of prejudice. This could be a trial with a crime on video and a signed confession. If this happened, a new trial would still happen. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence. Oh, yeah, this was a circumstantial evidence case. This is a circumstantial evidence case. And Murdaugh's credibility was a key component of his defense. I agree. And his credibility and the evaluation of his credibility was tainted by the clerk. They go on to say, finally, we hold that the state has not met its burden of proving that the trial court's instructions to the jury cured any prejudice from Hill's comments. The trial court never had the opportunity to even attempt to cure the prejudicial effect of Hill's comments because they did not come to light until months after the trial. In summation, Murdaugh met his initial burden in establishing Hill's comments to the jury were more than innocuous interventions, triggering the Reamer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly improper comments. Accordingly, we hold that Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for new trial. The court says, because we order a new trial on the basis of Hill's improper influence on the jury on appeal from an order denying Murdaugh's motion for new trial, it is not necessary that we address the evidentiary issues Murdaugh raises on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. We don't have to talk about this, but we think we should. At the time of trial, Murdaugh had been accused of and indicted of numerous financial crimes. During his testimony before the jury, Murdaugh admitted he had committed the financial crimes, although he had not at that time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to a concurrent 27 years in prison and 40 years in federal prison. The state sought to admit evidence of those financial crimes during the murder trial for the purpose of showing his motive for committing the murders. Murdaugh filed his motions. The trial court conducted a lengthy pretrial hearing, but declined to rule on the admissibility of the financial crimes evidence at that time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses. After hearing this testimony and the arguments of both sides, the trial court found all evidence of financial crimes that may likely have led to a motive or lend itself to motive was admissible. Murdaugh goes on to challenge the admissibility under the rules of evidence. I'm not going to go through each of the rules of evidence. We agree with the state that evidence of Murdaugh's financial crimes made the state's theory of motive more probable. Thus, we find that the trial court acted within its discretion in finding the financial crimes evidence was relevant and admissible. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to 404B or 403. We address this question in two distinct categories of issues. They're doing a full ruling on this too. The first of these categories, whether the trial court should have excluded all of the financial crimes evidence, is a point on which not all members of the court would have ruled the same way had we been the trial court. We each agree, however, this was a decision within the discretion of the trial court under the facts and circumstances that existed. As to the second category, so they punted that. They're not unanimous, so they sidestepped it. As the second category, we will address whether the trial court should have restricted the extent to which the state was allowed to present this evidence. That is, whether the trial court should have excluded some of the evidence. We unanimously hold that the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive. However, we hold that the trial court acted within its discretion in admitting some evidence of the financial crimes. Again, just not too much. We emphasize, however, the trial court should have limited the state's presentation of this evidence. By our calculation, the state spent a total of 12.5 hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdaugh's financial crimes. And that becomes a separate trial. We are convinced the state could have effectively presented evidence to support its motive theory in a fraction of the time. By holding that the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence be admitted on retrial. As is often the case, the facts and circumstances on retrial may be materially different from those presented in the initial trial. Thus, the trial court on remand must do as the trial court did here. Carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation or inflammatory details with little to no probative value that was permitted in the first trial. Conclusion. As the Fourth Circuit declared, the Reamer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and the superbly competent and professional counsel for the state and defense. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. Footnote 15. Footnote 15. We commend the post-trial court, which inherited Murdaugh's motion for new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a clerk of court within the context of a murky area of law. The fault in this is solely on Courthouse Becky.
While we strongly disagree with the Supreme Court, we respect this decision because that's how the process is supposed to be played out. So now we must look to the future. What does this decision mean going forward for this office? First, Alec Murdaugh is currently serving a 27-year sentence for the financial crimes that he has admitted to in a guilty plea that we secured against him. And he has also waived his appeals for those financial charges. Additionally, he pled guilty to federal charges about 5 months after he pled to the state financial charges. He received a concurrent 40-year sentence in addition to the state's charges. So Alec Murdaugh will not be getting out of prison for several decades.
Which is good to know.
Currently, our office is reviewing the Supreme Court's order. We're meeting with members of our legal team and our staff. We're evaluating what our legal strategy will be going forward. As of right now, the state has 15 days to ask the state Supreme Court to reconsider its decision, and we have 90 days to appeal to the U.S. Supreme Court. However, it is currently my intention to seek a speedy retrial in the case against Alec Murdaugh.
And there's the answer to that.
Obviously, I always say this with the court's current decision. We obviously recognize that all defendants have the presumption of innocence unless and until they are proven guilty in a court of law, and Mr. Murdaugh will enjoy that presumption at this time.
Right.
Any other charges as a result of this?
We're not going to comment on any other possible. Obviously, the case against the former Colleton County Clerk of Court was referred to another solicitor for review. That solicitor made criminal decisions regarding the totality of her conduct. She pled guilty to misconduct charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time.
Right.
Yes, sir.
Did this ruling come as
Because he doesn't want
surprise, and what can you?
Because he doesn't want to say there's nothing else we can do.
And as far as the cost of a second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they have a right to have their case adjudicated in court even though they're not currently here. Their family members who they left behind have a right, for those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done.
We're still in that window for 3 more months. So obviously it is something that we are contemplating all of our legal options, and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on.
We all knew this was going to be the result, though. You can't tell me you haven't talked about it. It is a very politically appropriate answer, but you can't talk to me y'all haven't considered it, because we knew that this was going to happen.
How quickly do you expect you could be back to trial with this?
What does speedy trial mean to you? What are we talking about? Are we talking about fall?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
What? Will we see a Murdaugh trial before the end of 2026, or are we going to see it in 2027?
I know that you talked to Alec yesterday. What was your client's response to the decision?
Immediately into attorney-client privileged information. Hey, what did your client say? And they're more than happy to share it.
Yeah, Craig, we had told him that the argument went very, very well. We were very hopeful in the result. He didn't believe that it could be possible. And then yesterday, he was very gracious, thankful. This
is from this morning.
And he said, Jim, I'm seeing, I'm reading it, and it's still hard to believe. But he's glad to get that moniker off of him as a convicted murderer of his wife and son. No doubt about that.
Dick, you said...
He is now back to charged with the murder of his wife and son and awaiting trial for the murder of his wife and son.
A few months ago when you were here, you said that you were confident that he would have, quote, a fair shot at acquittal if there was a retrial. What makes both of you so confident?
Well, I think that everyone says, well, the jury convicted him so quickly, evidence was overwhelming. If you take away all those financial crime, prejudicial, victims testifying, the Supreme Court talked about that yesterday. You've got no forensic evidence, no fingerprints, no eyewitness, no confession, no video. The only thing they have is this. He lied about where he was.
The Snapchat video.
It's
Right.
not the only thing.
The motive is paper thin, and maybe it's better to understand what they don't have. That's why they went all in on that financial crime stuff. And of course, we know this jury was lobbied.
I love that they're using Bubba in the background. I love that they're using Bubba.
By the clerk of court to convict. So I think a retrial is going to result with a fair jury. I think gives him a chance for acquittal.
Several years ago, you both talked about this investigation that you were starting to coincide with the actual law enforcement investigation. This investigation, I assume, has been going on for several years now. Has it yielded any new leads? Is there a new...
That's a really good question. Has that investigation rendered anything fruitful? Look at the look between the two of them.
Working theory about if it was not Alec, who it could have been?
We do have information that's been provided to us.
Since the trial?
Since the trial. And there are, frankly, a lot of people out there who believe in Alec's innocence, who continue to work and provide us information. But
what kind of information?
Well,
that's a good question.
You know, potential third parties and potential motives.
That's not an answer. I like the questions, though.
And we can't disclose it here right now and don't intend to.
Can you characterize the nature of it? I mean, are we talking text messages? Are we talking...
I can't characterize the nature of it, Craig.
And by the way, I wish we could talk about it, but...
Poot's like, Jim, hold on. You haven't politicked this well enough, Jim. Let me step in. I sure do wish we could talk about that. I sure do wish we could talk about that, but yeah, we're just going to have to wait.
I think this reversal is going to give us much more access to that information. Either these folks...
So you don't have any information? You don't have any information? It's going to give us more access to the information.
Either these folks that were hesitant to tell everything will come forward and tell us that. But more importantly, we now have the power of subpoena. We have the power to investigate this using the legal process.
A number of the jurors after the trial said that they thought Alec taking the stand was a mistake, that it hurt him.
I think they said it sitting on that couch on the Today Show that they thought Alec testifying hurt him.
If in a retrial, does he take the stand again?
Well, everybody misunderstands. We don't tell a defendant to take the stand or not. We give them advice, especially when your client is a lawyer. They're going to...
Yeah, I don't think they told Alec what he was going to do or not. I think Alec was telling them exactly what he was going to do. Poot's right about that. It's Alec's decision if he's going to testify or not.
Make that independent judgment. So the guy that can answer that question isn't here this morning.
But I do want to point this out.
No, he's in prison.
That jury was tampered with. That jury was told, don't believe Alec before he got on the stand in so many words.
That's a fair point,
so
Jim.
The jurors came out saying, we didn't believe him, but they were coached to...
Jim, better answer than Poot. That's a good answer.
Not believe him. And as the Supreme Court said, Becky Hill put her finger on the scale of justice and
she did do that.
The result of that trial.
The state has indicated they want to retry him quickly. If there's an about face and the state says, we're willing to offer a plea deal. We don't want to go through this again. We want to save the taxpayers some...
No plea.
Wow.
No plea.
Under any circumstances.
Under any circumstances.
He will never plead.
Never plead guilty.
Killing his wife and son, I promise you.
Who pays you guys? I mean, this has been going on for several years now. He allegedly has no money. How are you guys being compensated?
I'm going to defer to Jim on this because this is a discussion he and I have all the time.
Yeah. So,
is it pro bono?
Poot's like, this is a discussion we have all the time. I wonder if Poot's like, hey, Jim, we done here, my guy? How we getting paid? Who's paying me?
Craig, we got paid to try the first case.
Okay.
And there's no more money left. But when you do this work, you represent a criminal defendant. I mean, it's like you got paid for a job, and the job's not done. So, you know, it's a loss leader right now. We're doing it. We're not getting paid, but we're going to see it through.
And we're looking for avenues to perhaps get some money for
Taxpayers of South Carolina, how you doing?
You know, expert, not for us, but for expert witnesses.
Yeah.
I mean, the costs in the first trial were $600,000.
Dig, Jim, I wish we had more time, but thank you. Thanks for making
The costs were $600,000 costs. That money's got to come from somewhere. If you're going to bring in your experts, it's going to be real interesting to see what happens there. Alec Murdaugh is getting a new trial because Courthouse Becky interfered with this jury. And the South Carolina Supreme Court called it literally everything but a child of God. It was breathtaking, shocking, egregious, nefarious. They called the behavior of Courthouse Becky essentially one of the most appalling things that they have ever seen, an interference unknown to the South Carolina Supreme Court. They have never seen this level of interference with a jury. They basically said, you have fucked around way too much. And remember, Courthouse Becky was prosecuted for perjury in that hearing with Justice Toll regarding the new trial motion and abuse of her position for a number of things, including stealing and the private tours. And she got probation and restitution. And it is going to cost the taxpayers of South Carolina millions to do this trial again. Attorney General of South Carolina, Alan Wilson, said that they are seeking a speedy retrial and that they hope, though that hope is ambitious, they hope that they will retry Murdaugh before the end of 2026. That would be incredibly fast. I guess we'll see what happens. The first trial did go to trial within a very quick and short period of time, so maybe we will see this one also moving towards a speedy trial. That was a great interview with the defense as well from the Today Show, asking the questions that we actually wanted the answers to, which was fantastic. How are you guys getting paid? Murdaugh's broke. And Jim and Poot said that they got paid for the first trial and that there's no money left. And they're going to be looking at ways to get money for the expert witnesses. I imagine we'll see motions in court about that. We also saw a lot of questions about what's the strategy now for both sets of attorneys. And everybody was like, oh, we're not going to talk about that. And where do you go from here? And from both sides at these press conferences, both sides said, where we go from here is to trial. There is no plea. There is no conversation. We are going to trial. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.